Welcome, everyone, to ACE Your RDS Exam Case Studies Deep Dive.
Hello.
Today, we're jumping into some real disciplinary cases, looking at what actually happened with real estate salespersons.
Yeah, it's a great way to see the rules in action, not just theory.
Exactly. Think of it like learning from past situations, seeing where things can go wrong. So hopefully you can avoid those pitfalls. It's kind of a shortcut to understanding the responsibilities.
Definitely. You see the why behind the rules.
We've got some, I think, really interesting examples lined up. Things like misleading ads, issues around HDB rules.
Like the minimum occupation period, yeah. And even some serious stuff involving like forgery and the anti-money laundering checks. Really crucial topics.
We'll treat each one as its own little story, pulling out the key facts and what you really need to take away.
Sounds good.
And hey, before we dive into that first case, if you find this useful, please do give this deep dive a like and definitely subscribe to the channel.
Yeah, that way you won't miss out on future deep dives. We'll keep bringing you content to help you prepare.
Okay, ready for case number one?
Let's do it.
All right, this first one. It involves misleading advertisements. A salesperson got fined, suspended. Sounds serious. What exactly went down?
Yeah, this one is all about accuracy, or, well, the lack of it. The main problem was the salesperson was advertising new developments, but the prices they listed were way off, like significantly lower than what the developers were actually asking.
How much lower are we talking?
We're talking big numbers. The sources mentioned differences from $260,000 up to over $1 million.
There's $1 million. Wow, okay. That's not just a small mistake.
Not at all. And it wasn't a one-off either. This happened with 3 different property developments.
3. Over what period?
This was happening in late 2021 and sort of early 2022.
Okay, so a pattern.
Yeah.
But here's the key question. Did they just get the prices wrong, or was the correct info available?
That's the crucial part. The correct price information was available. Their agency had like a mobile app, even a WhatsApp group chat with the updated prices.
So the tools were there.
The tools were there, yeah. But the salesperson didn't verify the prices they were using in their ads. They didn't check with the agency, didn't check with the developers.
Right. That definitely sounds like it breaks a specific rule.
It does. Directly hits CEPCC paragraph 12(4)(a). Basically, that rule says your ads can't have anything inaccurate, false, or misleading. It's pretty black and white.
And the disciplinary committee, they didn't buy it was just an accident?
No, they didn't. Their finding was that it was deliberate. They used the term grossly misleading, not genuine mistakes.
Deliberate. So what was the point? Why advertise fake low prices?
Well, the motivation they identified was that the ads were basically bait, put out these super low, unrealistic prices to grab attention.
Like a lead generation tactic.
Exactly. Get potential buyers interested, make them call or message, and then try to build a relationship from there, even if the initial price wasn't real.
Okay. I can see how that would cause problems. It's misleading people from the get-go.
Totally. Misleads consumers, first off, and it's unfair to other agents who are playing by the rules advertising the correct prices.
Right. Makes them look uncompetitive.
Yeah, and it could even hurt the developer's reputation, right? If buyers see wildly different prices floating around for the same project, creates confusion, maybe mistrust.
Makes sense.
Yeah.
So given it was deliberate, misleading across multiple projects, what were the final consequences for the salesperson?
They were convicted on 3 charges for this. The penalty was a total fine of $14,000 plus a 5-month suspension. That started back in October 2023.
14,000 in 5 months. That's significant.
It is. And the industry perspective here really hammers home a key point. That salesperson's, like other professionals, they mentioned doctors as an example, you have to be answerable for what you do and the advice you give. It's not okay to just say, oops, when you get fundamental facts wrong.
So continuous learning is key. Staying updated.
Absolutely. Things like CPD, looking at case studies like these, it's all part of being professional. And the big takeaway, verify. Verify your information. Don't just assume, check it, double check it. It's your responsibility.
Okay, that first case really drove home the need for accuracy in what you put out there. The second case study shifts gears a bit, focusing more on knowing the rules themselves, specifically HDB rules and the minimum occupation period, the MOP.
Right. And this touches on a really fundamental requirement for any salesperson. You've got to know and follow the laws and rules for property transactions. Especially with HDB, their regulations are critical.
Absolutely. And the MOP is, well, it's a big one. Maybe just a quick reminder for everyone, what is it exactly?
Sure. The MOP, Minimum Occupation Period, it's basically the set time you have to actually live in your HDB flat before you're allowed to sell it on the open market.
And it starts from when you get the keys.
Starts from key collection, yeah. But, and this is important, any time you weren't physically living there doesn't count towards the MOP.
Okay, that's a key detail. And the sources also mentioned something about the HDB intent to sell.
Ah, yes. Using that online tool, the intent to sell function, it only gives you an indication if you might be eligible. It's not the final green light. You can't just rely on that and assume everything's okay.
Good point. So this case really highlights specific advice, doesn't it? What should an agent do if they suspect MOP isn't met?
The advice is crystal clear. If you know your client hasn't met the MOP, maybe they tell you straight up, oh, we never moved in, or you see the place and it's clearly untouched, never occupied, you absolutely must refuse to market the flat.
Just refuse, even if the client pushes.
Yes. You have to explain the MOP requirement clearly, and even if they insist you cannot proceed, your obligation is to follow the rules, not just the client's instructions if they contradict the rules.
Okay, so let's get into the specifics of this case. What happened here?
All right, so the salesperson was helping owners sell their BTO flat. Build-to-order HDB flat. They got the keys way back in May 2015.
Okay.
But, and here's the kicker, they never actually lived in it. Never physically occupied the flat. They stayed somewhere else. They mentioned reasons like finances for renovation, needing to be with an elderly parent.
And the salesperson knew this.
That's the critical finding. The salesperson was aware that the owners hadn't lived in the flat since getting the keys.
Oh, boy. So knowing this, what did the salesperson do?
Well, in December 2022, they went ahead, took photos of the flat, which was still unrenovated, bare condition, and put it up for sale online.
And the ad even mentioned the bare condition.
Yeah, apparently tried to spin it, saying something like, reno to the way you like. The owners later said the salesperson never actually advised them about the MOP rule before putting it on the market.
Wow. And what happened to the owners? This sounds like it could backfire badly on them.
It did, really badly. The consequence for the clients was severe. HDB compulsorily acquired the flat.
They lost the flat.
They lost the flat.
Yeah.
Because the MOP wasn't met and it was improperly marketed.
That's devastating for the clients. So what rules did the salesperson break?
They breached a couple of key CEPC paragraphs. Paragraph 4.1 read with 4.2e. That's the one about having to comply with laws and rules, specifically HDBs here. And also paragraph 7.1, which is about conduct that brings discredit to the industry.
And the penalty for the salesperson.
They got a letter of censure and a financial penalty of $1,000.
Okay. The industry take on this seems pretty direct.
Yeah, it really circles back to basics. Know the HDB processes, know the guidelines, know the code of ethics, and importantly, if you're ever unsure about anything,
Ask. Find out.
Exactly. Proactively seek clarification. Don't guess. Don't assume. And the message is stark: going ahead and marketing a flat when you know the MOP conditions aren't satisfied. That's just not acceptable. Highly inappropriate.
It really stresses acting responsibly right from the start.
Absolutely. Because, like this case shows so tragically, sometimes you can't undo the damage later, especially when the client faces such a huge loss.
Okay, moving from advertising accuracy and HDB rules, our third case study tackles something really critical in today's environment: financial crime prevention. This agent faced consequences for forgery, but also for failing on the AML-CFT checks.
Right. AML-CFT, anti-money laundering, and countering the financing of terrorism. This is a huge deal globally, and Singapore has specific rules for estate agents.
The PMLFT regulations.
Exactly. The Estate Agents Prevention of Money Laundering and Financing of Terrorism Regulations 2021. They basically require agents to do customer due diligence CDD, report anything suspicious, and keep good records.
CDD. So that's really about knowing your customer.
Right.
Understanding who you're dealing with and any potential risks.
That's the core idea, yes. You need to identify your client, verify their identity, and assess the risk.
So what was the situation in this specific case?
Okay, this involved a salesperson who was co-broking, working with another agent to sell a property. The property belonged to a company, let's call it Company B.
Okay, the seller was a company.
Right. Now, the option to purchase was exercised, but then sadly, the partner agent passed away.
Oh, wow.
Yeah. So this salesperson then submitted the transaction paperwork to their agency to get the commission. But here's the problem. They hadn't done the required customer due diligence checks on the client, Company B.
They just Didn't do the check.
or didn't do them correctly. The sources list several specific failures under Section 44B2A of the Estate Agents Act.
Okay, what kind of failures are we talking about?
Well, first, a really fundamental one. They didn't properly assess the money laundering or terrorism financing risks. Why? Because they actually mistook the client. They thought the client was an individual, someone named C, who they assumed was the beneficial owner of the company.
Wait, so they thought the client was person C, but the actual client was company B.
Correct. So they ended up performing checks, whatever checks they did, on the wrong entity entirely.
That's a massive error right at the start. What else went wrong with the CDD?
They failed to get, document, and verify the proper identifying information for the actual client, company B. Didn't collect enough details. And they didn't verify the company's identity using reliable sources, like, say, submitting a business profile from ACRA for company B.
And because the client was a company, an entity, there are extra steps needed, aren't there?
Yes, precisely. When your client is an entity, not an individual, you have additional obligations. You need to identify and verify things like the company's full name, its legal status, proof it actually exists, understand its ownership structure, who the beneficial owners are, the nature of its business.
And they didn't do that.
Nope. Didn't do those checks. In fact, on the agency's checklist, they wrongly marked that the client was not an entity, and they marked the part about verifying the beneficial owner as not applicable. Just completely missed the mark on dealing with a corporate client.
Okay, so that covers the failure to perform CDD. But you mentioned forgery, too.
Yes, and this is where it crosses into outright dishonesty. The salesperson filled out the customer's particulars form, but they filled it out for the individual C, not company B.
The person they mistakenly thought was the client.
Right. And then they forged C's signature on that form.
Forged the signature.
Seriously.
And then they submitted this forged form, along with the agency agreement, which actually had a different signature for C on it, to their agency to claim their commission. Whoa. So submitting a forged document to get paid? That's a huge breach.
Massive. That's a direct breach of CEPCC paragraph 7.1, read with 7.2a. Bringing the industry into disrepute through dishonest conduct, specifically forgery.
Were there any other red flags they missed? Signs of negligence?
Yes. Apparently, the salesperson had seen other documents, maybe from the deceased partner, that had C's signature on them, like a tenancy agreement. They should have noticed the signature on the agency agreement they were submitting looked different.
But they didn't question it.
Didn't question it. Just showed a lack of basic diligence. Oh, and they also kept advertising the property online even after the option had already been exercised by the buyer. Another oversight.
So it's a whole bundle of issues. Botched CDD, forgery, lack of diligence. What was the outcome?
They were convicted on two main charges: the failure to perform CDD and the forgery charge. Two other related breaches were also considered when sentencing.
And the penalty?
A fine of $9,000 and a suspension for 5 months.
Okay. The industry perspective here seems particularly relevant given the focus on AML-CFT.
Very much so. It really highlights Singapore's zero tolerance for money laundering and terrorism financing, and how these PMLFT regulations are being taken extremely seriously within the real estate sector.
Seems like this could be a landmark case for enforcing these rules.
Potentially, yeah. The message is that the CDD requirements, the checklists, the forms, they're meant to be straightforward, and messing them up is not taken lightly.
So the big takeaway for agents listening:
you absolutely have to stay current with these regulations. And crucially, even if you're co-broking, if you're the one closing the deal and submitting the paperwork for commission, the responsibility for proper CDD falls on you.
You can't just rely on what your co-broke partner did or told you.
No, you can't blindly trust. You need to do your own checks, verify the information yourself. Diligence, accuracy, honesty, they are absolutely fundamental.
So we've walked through three quite different scenarios: misleading ads, breaking HDB MOP rules, and then this complex case of AML-CFT failures mixed with forgery. Looking back across all three, what are the sort of common threads or overarching lessons?
Yeah, stepping back, a few really key themes emerge, I think. The first one, loud and clear, is just the fundamental need for accuracy and honesty in everything. What you say, what you write, what you advertise.
Right. No fudging the numbers, no misleading claims.
Exactly. And linked to that is the absolute necessity of being fully informed. You have to know the rules. The CEPCC, the Estate Agents Act, specific things like HDB regulations, the AML-CFT requirements. You need to know them and comply.
Ignorance isn't an excuse, basically.
Not at all. And failing to check, failing to verify, that doesn't fly either.
Yeah.
Which brings up the third point. Personal responsibility for due diligence.
Meaning you can't just pass the buck.
Pretty much. You can't just rely on what a client tells you or what another agent says or assume information you saw somewhere is correct. You, as the professional, need to do your homework, verify things yourself.
Makes sense. Be thorough.
Yeah. And the final, maybe sobering, theme is the consequences. These aren't just slaps on the wrist. We saw significant fines, suspensions, formal censures.
And not just for the agent, right? The MOP case showed devastating consequences for the client.
Exactly. Your actions or inactions can seriously harm your clients. And beyond that, every breach damages the reputation and trustworthiness of the entire real estate profession.
So understanding these real cases, the details, the outcomes, it's really essential preparation, isn't it? Whether you're studying for the RES exam or you're already practicing.
Absolutely vital. It shows you the practical application of the rules and the very real stakes involved.
Well, that certainly was a deep dive into some tough, but I think really important case studies today. Seeing how these rules and standards play out in the real world is quite impactful.
Definitely. It moves beyond just reading regulations to understanding the so what. Hopefully, unpacking these examples has been genuinely useful for you listening in, whether you're gearing up for the RES exam or just thinking about your own professional conduct.
Yeah, we really encourage you to take a minute after this. Maybe just reflect on these situations. Think about the rules, the principles we talked about. How do they connect with your own understanding or your practice? Maybe ask yourself, what would I have done?
That's a great exercise.
And just to leave you with one final thought to mull over, something that builds on everything we've discussed today.
Okay.
Given the complexities we've seen, the absolute need for accurate knowledge, and the weight of responsibility highlighted in these cases, what concrete steps will you personally take moving forward to ensure you consistently maintain the highest possible standards of professionalism, integrity, and diligence in all your real estate work?